The Indian judiciary is currently sustaining a weight of over 5.5 crore pending cases. This burden is concentrated at the base. Over 4.5 crore of these disputes are currently held within the district courts. Public perception often treats the judiciary as a simple vertical ladder, assuming every case follows a straight line from the bottom to the top. But the sheer volume of litigation makes that linear model impossible. For the system to remain operational, it must structurally adapt. This grid shows how the system manages that volume. It operates as a routing matrix, moving cases towards specific courts based on 3 primary legal triggers. The first filter is criminal severity, which routes cases based on the maximum sentence a judge is authorized to give. The second is a pecuniary threshold, sorting civil disputes based on the specific monetary value of the claim. The third is a parallel track of specialized tribunals, designed to bypass the traditional court hierarchy for specific technical issues. Taken together, these filters form a dynamic sorting algorithm. To see how justice is actually administered, we have to look at how these triggers determine where a case ends up. At the absolute apex is the Supreme Court, the final interpreter of the Constitution. Its appellate jurisdiction, detailed here under Articles 132 through 134, allows it to hear challenges to judgments from the high courts, particularly in matters of constitutional interpretation, like the case of Ananda Bharathi case. Below the Supreme Court are the 25 high courts, each serving as the highest judicial authority within its respective state. Under Article 227, these courts exercise supervisory jurisdiction, allowing them to oversee and regulate the functioning of every subordinate court in their territory. These upper tiers are architecturally designed for oversight and legal review. They lack the trial infrastructure, specifically the witness boxes, evidence recording machinery, and investigative staff needed to handle raw, high-volume case intake. That high-volume intake is the primary responsibility of the subordinate courts. This diagram shows the criminal side under the BNSS, filtering cases through 3 tiers based on sentencing power. The highest is the Court of Sessions, passing any sentence authorized by law, though death sentences require high court confirmation. The middle tier, the Chief Judicial Magistrate, is restricted to sentences under 7 years. The base tier, Judicial Magistrates of the first class, handles the highest volume, limited to 3 years or 50,000 rupee fines. This criminal routing acts as a severity sieve, trapping minor offenses at the base to ensure the higher courts are not paralyzed by low-level infractions. Civil disputes use a different filter. Here, the trigger is the monetary value of the dispute. Under Section 15 of the CPC, the principle of least congestion requires that a suit be filed in the court of the lowest grade competent to try it. This slider shows the pecuniary limit currently used in Delhi. Original civil suits valued over 2 crore rupees are directly to the High Court, bypassing the district level entirely. In 2025, the District Bar Association proposed shifting this limit from 2 crore to 20 crore rupees. This would instantly reroute a massive volume of high-value cases back into the district courts to relieve pressure on the High Court. The Delhi High Court Bar Association, or DHCBA, has formally opposed this move. They argue that district courts currently lack the specialized staff and infrastructure needed to manage complex intellectual property or international arbitration disputes that often fall into that 20 crore bracket. Pecuniary limits are administrative valves. Adjusting them is a trade-off. It is speed up the system, but may reduce specialized scrutiny for complex cases. The third way the system manages the 5.5 crore caseload is by moving disputes into a parallel track. This branch represents the impact of the 42nd Amendment. Articles 323A and 323B allow the creation of tribunals that cases can enter without going through the district or high court notes. These tribunals provide domain-specific technical expertise and use simplified procedures to resolve disputes faster than a traditional court. This includes the National Green Tribunal for Environmental Law and the NCLT for Corporate Insolvency and Debt Recovery. However, the Supreme Court established a constitutional safeguard in the case of L. Chandra Kumar. The ruling clarified that while tribunals can substitute for lower courts, their decisions are always subject to judicial review by the high courts under Articles 226 and 227. Tribunals offer a faster, specialized track for administrative and economic governance, creating a vital bypass for the traditional judicial spine. This completed model shows the SC-HC spine, the criminal severity filters, the pecuniary valves, and the tribunal bypasses all working at once. But despite this architecture, the system is hitting operational limits at specific nodes. The tribunal ecosystem is hampered by vacancies. For instance, the NCLT has recently operated at only 50% capacity. There is also ongoing friction over executive control in appointments, which can compromise tribunal independence. Meanwhile, the district courts lack the physical courtrooms and digital management systems needed to make large pecuniary shifts, like the 20-crow hike, effective. A sophisticated sorting logic fails if the specific courts at the end of the line do not have the staff or facilities to receive and process the cases routed to them. Ultimately, adjusting pecuniary limits or creating new tribunals does not remove cases from the 5.5 crore backlog. These strategies merely redistribute the load, moving the pressure from one part of the judiciary to another. Long-term stability requires the state to expand the actual capacity of the district courts, rather than relying on bypasses at the top. The architecture of Indian justice is a balancing act between managing volume and maintaining legal expertise. In this system, every procedural bypass requires a trade-off in the quality of legal attention a case receives.